From the very first line, look at this. Lower court judges, talking to you, unelected black robe tyrannical inferior district trial court judges, may sometimes disagree with this Supreme Court's decisions, but they are never free to defy them. There is a hierarchy of authority here, MFers. Just because you got, after Trump's election, raised to the federal bench and given a black robe does not mean you're superior to the Supreme Court of the United States. In Department of Education versus California, a recent decision out of the Supreme Court addressing essentially as identical issues as here, this Supreme Court sided with Trump, saying he didn't have to pay money because the unelected black robe tyrannical district trial court lacked jurisdiction to order the government to pay money. Why did the district court lack jurisdiction to order the government to pay money? Because those claims are stripped from the federal trial courts by Congress and placed in the Court of Federal Claims. You have no jurisdiction here. We told you that just weeks ago. When it comes to forcing the government to pay out on contracts, that Supreme Court decision of California explained that suits based on any contract with the United States do not belong in district court under the APA or any other grounds, but belong in the Court of Federal Claims. Rather than obey our clear orders, this unelected black robe tyrannical inferior district trial court judge permitted a lawsuit involving materially identical money questions to proceed to final judgment under the legal argument we already said here does not apply, the APA. As support for its lawless orders, the trial court invoked the persuasive authority of the dissent in California. In other words, the Supreme Court issues a decision. There's a majority and a dissent. The majority is the law. The majority is what every court is required to follow. The dissent is just an explanation of the losers. It has no legal authority. By the way, who wrote the dissent in California? Justice Ketanji Waffle House Brown. She lost there, and this trial court judge decided that the losing argument in California is what they're going to follow in an essentially identical case. Absolutely outrageous. Unimaginable that a trial court judge would say, yeah, I see this recent, weeks ago, ruling from the Supreme Court on essentially the identical issues, whether the government can be forced to pay out money. And instead of abiding by the majority opinion, the authoritative legal precedent, majority opinion, I'm instead going to apply the losing opinion. In that case, it does not have any legal authority. And I'm going to pretend that supporting that misjudgment on my part, I'm also going to be guided by an appeals court decision of that same case that was reversed by the Supreme Court. I just hope those of you who are not lawyers understand how egregious this is. It's as if a bunch of you serve in the military, right? You have a commanding officer. There's a chain of command. The commanding officer issues an order. And then some private who's peeling potatoes says, I think that's a bad idea. I think we should really do it the other way. And you decide to follow the private's orders over your commander officer. What would happen to you? Would you remain in command? Would you keep your rank? But nothing happens to Ketanji Waffle House Jackson, does it? Or this inferior trial court judge. So when the judge decided, instead of following the majority in California, the Supreme Court decision, and instead following the losing dissent in California, that was error. And it has to be malicious error. Gorsuch is quoting now, unless we wish anarchy to prevail within the federal judicial system, a precedent of this Supreme Court must be followed by the lower federal courts, no matter how misguided those judges may think it to be. We are in command, the Supreme Court, not you effing potato peelers in the districts. In casting our majority decision in California aside, the unelected black robe tyrannical inferior district trial court stressed that the Supreme Court in California granted only interim relief. It was a stay of an injunction. It wasn't a decision on final judgment on the merits. And that's true. But this Supreme Court often addresses requests for interim relief, like they are here, and sometimes pending a writ of certiorari, as in California. And either way, when this Supreme Court issues a decision, it constitutes a precedent that commands respect in lower courts. You punks. This is Gorsuch's "get off my lawn." Regardless of a decision's procedural posture, whether it's an interim decision or on the final merits, its reasoning, its legal logic, its ratio descendende carries precedential weight in future cases. And California Supreme Court, the Supreme Court decision of California's reasoning was clear. Are you an idiot? Gorsuch is asking. There, this Supreme Court explained that the APA's limited waiver of immunity, that the government normally has immunity from being sued. The APA says you can sue for arbitrary and capricious policy. So it's a waiver of normal government immunity. The APA's limited waiver of immunity does not extend to orders to enforce payment of money, contract disputes. Instead, the Court of Federal Claims has jurisdiction based on any express or implied contract with the U.S. That reasoning from California, the Supreme Court case of California, binds lower courts as a matter of vertical stare decisis. In other words, the authority runs downstream. The notion that any judge, any lawyer could have any confusion about the hierarchy of authority in the federal court system is outrageously insane. Obviously, when the Supreme Court tells a trial court to do something, the trial court has to do it that way. Gorsuch continues. The promise of our legal system that like similar cases are treated in a similar manner means that a lower court ought not invoke the quote-unquote persuasive authority of a dissent or a reversed Court of Appeals decision to reach a different conclusion than the Supreme Court on an equivalent record. The trial court here did try to distinguish California from this case, but that effort failed too. This case, the trial court asserted, is somewhat different from California because the claim in California concerned only money. But the same holds true here. The only injury the trial court sought to remedy was the money that was being denied. And because this is really a money case and California was a money case, California controls. The Court of Appeals, sensing this vulnerability and the trial court's lack of reasoning, tried to distinguish California in different ways by conflating in the APA arguments. They invoked the APA to vacate the government's decision to terminate the respondent's grant. So here they tried to conflate the APA, those rules are arbitrary, capricious on the one hand, with the government has to pay money on the other hand. But Gorsuch writes, this court's precedents cannot be so easily circumvented. An order vacating The government's decision to pay money under the APA is in every meaningful sense an order requiring the government to pay money, and therefore it belongs in the Court of Federal Claims. The Court of Appeals also, they're being reversed here by the Supreme Court. So he's saying wrongfully asserted that unlike in the earlier case, Supreme Court case of California, the claims here do not depend on the terms and conditions of the grant, but that is also incorrect, you dummies. In both cases, the claimed injury and the alleged right to payment stems from the government's refusal to pay the promised grants. For these reasons, I concur in this Supreme Court's decision to go with Trump and not obligate Trump to pay the money. If the trial court's failure to abide by our Supreme Court California decision were a one-off, here we get super hot. Here, Gorsuch is going to explain to the whole world that these effing unelected black robe tyrannical inferior district trial court judges are in open rebellion against the authority of the Supreme Court and therefore against the authority of our constitutional order. Listen to this. If this unelected black robe tyrannical inferior district trial court's failure to abide by our Supreme Court precedents in California were a one-off, perhaps it would not be worth writing to address it. But it's not a one-off, is it? 2 months ago, another district court tried to compel compliance with a different order that this Supreme Court had also frozen. Still another district court recently diverged from another Supreme Court decision, even though the cases did not differ in any pertinent respect. So this is now the third time in a matter of weeks that this Supreme Court has had to intercede in a case squarely controlled by one of its precedents. This is the local street cops having to come into Waffle House for the third time that week because the denizens have poor emotional control. It's not a one-off. This is a pattern of insurrection against our constitutional order. If this is not grounds for removal from the bench, what is? And let's not pretend that we don't know that these judges are all coordinating. These TDS judges engage in this lawfare to impede the policies of the Article 2 elected president, elected by the whole of the American people to carry out our will, to stop DEI cultism, to stop the application of race in governmental policy. Let's not pretend that these judges are not coordinating what they're doing. This is a coordinated insurrection against our constitutional order. Now, for the third time in a matter of weeks, this Supreme Court has had to intercede in a case squarely controlled by our precedents that the trial courts are just refusing to abide by. All these interventions should have been unnecessary. Why are you making me come in here and arrest you people again? Just eat your waffles. No, we don't have ribeye here. That's not this kind of joint. You get waffles. But together, they underscore a basic tenet of our judicial system. That this has to be explained to federal court judges is unbelievable. A basic tenet of our judicial system. Whatever their own views, judges are duty-bound to respect the hierarchy of the federal court system created by the Constitution and Congress. Bam! The U.S. Constitution, they don't call it the Supreme Court for nothing, dummies. We are the Supreme Court because we are supreme. And all you inferior courts are merely creations of Congress, not creations of the Supreme Court like us. Kavanaugh decides to add his own 2 cents to all this. Remember Kavanaugh? Remember when he was going through his confirmation process and they brought in that insane woman who for the first time in her life fabricated a story how when Kavanaugh was in high school, He Me Too'd her. Whatever happened to her? Whatever happened to her lawsuit against Kavanaugh? No super chats? I was kind of expecting super chats, folks. Everyone tired? I got to a big pause in the decision and there's no super chats. All right. Kavanaugh. He writes, like Justices Thomas, Alito, and Gorsuch, the sane ones, I would grant Trump's application for an interim stay in full, meaning Trump doesn't have to pay the money, which Barrett joins, so that's a majority, and these policies are not subject to the APA in federal district court. So Kavanaugh would give Trump both wins, not just the money win. First, Kavanaugh says, I agree with Trump and the majority in the Supreme Court that the plaintiff's claims about the money belongs in the Court of Federal Claims, not in federal district court. This Supreme Court has already decided this in Department of Education versus California just weeks ago. The reason for that decision and this one is straightforward. The core claim is termination of money. That's a breach of contract claim, and it belongs in the Court of Federal Claims, not federal district court. This is not rocket science. Second, Kavanaugh writes, I also agree with the government that the claims around the grant terminations, the guidance, the executive orders, whether they're arbitrary and capricious, is likely unavailing. For starters, it's not evidence that their challenge to the guidance is really separable from their challenge to the grant terminations. But even if it is, they're unlikely to succeed on the merits of their arbitrary and capricious challenge to the executive orders for reasons the government's already persuasively explained. So now he's going to quote Trump's arguments. Why the claim that the executive orders were arbitrary and capricious is silly. Why is it silly? Because like one of the arguments they make, I mentioned earlier, they said, well, it must be arbitrary and capricious because Trump doesn't define what DEI is. I love this argument. Well, you know, you can't even really, what is DEI? You see this on social media too, the left, define DEI. And of course, DEI is an amorphous, anti-white, anti-American doctrine. It's like a bucket of snot. So however you define it, they'll say, well, no, your definition doesn't include this piece of snot over here, so it's wrong. But here's what I know. DEI was not invented as a concept by Trump. DEI was not incorporated into NIH policy by Trump. NIH's policy saying they are going to favor DEI suggests to me they're making decisions about who gets money based on their DEI status, which means the NIH somehow is defining DEI. They know what DEI is, or they couldn't apply it in their own policies. It's like these people, I hear similar arguments. Sorry, I'm going to make all the pit bull owners mad again. I hear similar arguments from the pit bull owners. Whenever someone says, we should ban pit bulls, one of their responses is, well, pit bull's not actually a defined breed. So you can't ban what you can't define. All I know is this. When somebody wants to own a pit bull and they go to the shelter, somehow they manage to come home with a psychotic pit bull. They never come home with a Chihuahua, right? They never mistakenly come home with a golden retriever or a Labrador. When they want a pit bull, you can't define what a pit bull is. Somehow, they always come home with a pit bull. Somehow, they're able to know what it is when they see it. The same with this BS, well, you're not defining DEI. Bullshit. Anyway, Gorsuch is now quoting from Trump arguments. Quote, the district court's principal objection was that the NIH never defined the term DEI. But there's no government rule that agencies have to define every term in every internal guidance document, particularly when that guidance steers highly discretionary decisions about how to allocate limited agency resources. Agency guidance documents do not need to come with glossaries just to avoid APA invalidation.
Thanks for watching this highlight segment of our full-length Law of Self-Defense livestream. If you enjoyed this content, make sure to give us a like and subscribe for more expert analysis on politics, law, and how to be hard to convict. And to watch the full-length episode of this show, just click right here. Stay safe.